5 seconds to go. Start. Shri Gupta further argued that in the present case, what was prayed for was a writ of quo warranto, and in fact, the election of the appellant was not called in question. It was argued that since the writ petitioners came to know about the appellant not belonging to the scheduled caste, and since the post of the chairperson was reserved only for the scheduled caste, therefore, the High Court was justified in entering into that question as to whether he really belongs to scheduled caste. In short, the learned counsel argued that independent of the election of the appellant as a ward member or as a chairperson, his caste itself was questioned in the writ petition only with the objective to see whether he could continue as the chairperson. This argument is clearly incorrect, as the continuance of the appellant as the chairperson was not dependent upon something which was posterior to the appellant's election as chairperson. It is not as if some event had taken place after the election of the appellant which created a disqualification to continue as the chairperson. The continuance of the appellant as the chairperson depended directly on his election, which election was available only to the person belonging to the scheduled caste. It is an admitted position that ward number 8 was reserved for scheduled caste, and so also the post of chairperson. Therefore, though indirectly worded, what was in challenge in reality was the validity of the election of the appellant. According to the writ petitioners, the appellant could not have been elected as a ward member, nor could he be elected as the chairperson, as he did not belong to the scheduled caste. We can understand the eventuality where a person who is elected as a scheduled caste candidate renounces his caste after the elections by conversion to some other religion. Then a valid writ petition for quo warranto could certainly lie, because then it is not the election of such person which would be in challenge, but his subsequently continuing in his capacity as a person belonging to a particular caste. The counsel for the appellant rightly asked that the question of caste and the election are so inextricably connected that they cannot be separated. Therefore, when the writ petitioners challenged the continuation of the appellant on the ground that he is not belonging to a particular caste, what they in fact challenged is the validity of the election of the appellant, though apparently the petition is for the writ of quo warranto. Again, merely because the appellant was described as being a Christian in the service records did not mean that the appellant was actually a person professing Christian religion. It was not after all known as to who had given those details, and further as to whether the details in reality were truthful or not. It would be unnecessary for us to go into the aspect whether the petitioner in reality is a Christian for the simple reason that this issue was never raised at the time of his election. Stop.